Welcome to a new video. Today we'll be discussing intellectual property, but mainly within the entertainment law sector. To do this, we have the fantastic Mrs. Nobantu Phumla Mfeka. She's an entertainment lawyer who specializes in entertainment property management, intellectual property management. She's currently the director of Mfeka Attorneys and is the managing director of a global entertainment law. Hi, Ms. Mfeka, how are you doing?
I'm doing very well. How are you today?
I'm doing good, thank you. I'm doing good.
That's great. That's great.
Would you like to give a brief introduction of yourself so we get to know you a bit better as well? The viewers get to know you a bit better.
Sure, you did a sterling job there. But outside of that, I am obviously, like you said, I'm Nobantu Phumla Mfeka, and I use both my names interchangeably. So you can call me Nobantu or Phumla. I am an entertainment lawyer, so you're absolutely correct. I'm also a mom, so I'm not just a lawyer. I have children, and I multitask amongst all these exciting activities. So I am an entertainment lawyer, like you said. I have a private practice under Mfeka Attorneys, as well as a boutique consultancy, global entertainment law. And yeah, I think in a nutshell, that's who I am. I'm a South African, depending on who's viewing this. I'm also a South African. So most of what maybe will be discussed today will be in the context of South African creative industries.
Thank you for the introduction. I happen to know you through my mother as well and through my dancing years way back when. I've managed to meet you through then, and you're a phenomenal person. So I'm extremely lucky to be interviewing you right now. So to jump into it, what is an entertainment lawyer? And what do entertainment lawyers do?
I suppose the best way to answer that one would be first to understand what entertainment industry encompasses. So that, to be a lawyer, you basically represent the interests of your clients. As an entertainment lawyer, you would then represent the interest of clients within the entertainment industry. So that would be your companies, studios, creatives, people who are producers of film, television, theater, publishing, music, visual artists, anything that kind of gets the world entertained. And so you would be the agent that represents the interests of those that are producing those works, that keeps society at large entertained. What does an entertainment lawyer do? We assist in reviewing and drafting of agreements in the industry, agreements between film producers and creatives or creators of content. We assist in the aligning those contracts according to the laws of each jurisdiction. Jurisdiction meaning, how does the law in South Africa require those contracts to look like? So we would assist in that regard. We'd assist them to protect their ideas. A lot of creatives come up with unique ideas. So in order for those ideas not to be easily stolen, we then would assist to protect those ideas in various forms. Obviously, we don't protect the idea itself, but we protect how the idea has been reduced. Yeah, so I think overall, it's what a commercial lawyer would do, but the specificities of it would be focused more within the industry of creatives and creative companies, or companies that are investing in creative assets.
Okay. With that, could you also maybe go into how because you are intellectual, you specialize in intellectual property management. So how would that also fit into entertainment law?
So maybe just a little bit of to add to my background earlier on. I was in the entertainment industry as a writing consultant or co-writing, both here in South Africa as well as I used to stay in Houston, Houston, Texas, and was quite involved in the entertainment industry. And what I saw at the time, I was obviously much younger, was that a lot of what is being created, or what in law we call it, in copyright law we call it, what is being reduced into a material form. So to a layman's language, if a song is written or if a screenplay is written, I saw that it was not always protected, right? It wasn't always protected. And so I became quite curious on what is it that you would then protect once somebody comes up with an idea in their mind and then they put it on a material form, whether recorded, how would then protect it? Then I was introduced to the area of intellectual property. And as the name says it, it is the property of the intellect. So it is the assets that you come up with from your mind, either in the form of a design, either in a form of a artistic work, either in the form of music, computer programs, sound recordings. So I then became curious, how, as a creative, how do you protect that? And I then was introduced to intellectual property. How they're interlinked. Most engagements in the entertainment industry are commercial agreements, right? So it would be, I have an asset that I've come up with and I wish to exploit it. I wish to develop it and distribute it around the world, but I want to make sure that I earn from that. And so in order to do that, you would then have a protection of your intellectual property. So if an agreement is entered into between, for example, say a producer and a writer, a screenplay writer, that there is intellectual property in her screenplay or in her script or in her lyrics. So that is how intellectual property interlinks to the entertainment industry. It's a huge component of it. You would offer that to either an investor. An investor would either take it via licensing or via assignment or purchasing in whatever form or shape. So I hope I'm answering your question. It almost cuts across the entertainment industry engagements that we do. So intellectual property is a cross-cutter between most commercial agreements that one enters into when they are in the creative industries. If you are a painter and you're sending your paintings to a gallery, there will be commercial agreements that are entered in that regard, right? So you would want to ensure that the property of your intellect, which is that painting, is protected, that the copyright within that is understood, that it belongs to you, you are the first creator of it, and that it cannot be used as and how without you being duly compensated. So that is how the two worlds are linked.
I think you did answer the question, showing that they work simultaneously and hand to hand. So you mentioned also working with copyrights earlier in your answer. And when looking into intellectual property, I found that the CIPC, or the Companies and Intellectual Property Commission, spoke about different domains for intellectual property. So I want you to find which domains do you mainly work with, and what do those domains mean within the entertainment industry in regard to intellectual property?
So perhaps maybe just to simplify it a little bit for some of our viewers, I would say I always make an example of intellectual property as in a form of a tree, a big tree, big African tree, and the different branches of the tree, or the different, what you are now referring to as domains. So with the branches, the different branches would be trademarks, that you would have patents, you would have copyright, you would have designs, right? Those are the different branches. So different assets are created from those different branches. I mainly specialize in copyright management and protection, as well as trademarks, right? Because patents by nature is more of a scientific area of creativity. So you would need normally lawyers who protect or engage in patent law, either have a scientific background, etc. And patent basically it protects invention, right? It protects when a new way of doing something has been invented and has not existed before. So you need to ensure that the classification of that newness is indeed new. So that's a specialized area. For me and my colleagues in our practice and consultancy, we deal with mainly copyright. Copyright is generally, I think the general definition is that it's a bunch of rights in certain, in some types of material, right? So for example, text, computer programs, sound recordings, films, and music. So again, it is a bunch of rights that exist in certain creative material forms. So when somebody says, I have an idea, up until that idea is reduced in some kind of a material form, in a form of a text or an artistic work, that idea remains an idea, right? So you can't say that they have copyright in a work. I also deal quite a lot with trademarks. Trademarks are basically what distinguishes one's products or one's goods or services from another. A good example would be, with Coca-Cola, you've got Coca-Cola, that brand distinguishes itself from other sodas that we have in the industry. You've got Nike. Nike distinguishes the brand, the logo, the look, differently to its competitors, perhaps Adidas and others like that. So a trademark would be the identifier, what is recognizable in the sign or in the design or the expression of a thing or a service that makes somebody be able to identify and say, okay, when I'm purchasing this brand, or when I'm engaging in this service, I'm engaging in that service which is different to another's. Every now and then we get requests for protection of designs. Again, that is another quite specialized area, and that would be a protection of shapes, configurations, patterns, just basically if somebody came up perhaps with a design in an art form and wanted to uniquely protect that pattern for maybe a fabric, and they wanted to come up with clothing with that specific pattern, you could then protect that design as well. Yeah, so that's generally the different branches, or what you said earlier on, domains of intellectual property in South Africa, and I guess in the world actually.
Yeah,
because we all operate under global laws.
true. So maybe just to also see if I understand you correctly. So copyrights are it's the actual idea materializing into something, as you said, text, or so it's once the idea is no longer in your head, but it's actually written and actually expressed into reality. Then, so am I correct there, or have I gone off?
Yes, we're on the right track. It's not as basic, but yes, I think that's the general idea, because obviously you also have to qualify if that idea is original, and there are various tests of qualifying originality, whether or not you've actually spent time, sweat of the brow to make sure that that idea in fact is original, because I can come up with an idea that's not really original and I can reduce it into a material form. It does not necessarily mean that I've now got reduced copyright. So there are various layers to it to ensure that that idea indeed has been reduced effectively, and it is an original idea. Now, in terms of reduction of an idea, I think that's gotten quite a a lot of people in trouble when somebody sees somebody else doing what they had envisaged to doing. For example, if you and I have a discussion right now and I say to you, oh, I have an idea of a cooking show, right? Until I've reduced that idea in some kind of material format, it remains a commonplace idea. Anybody else can have an idea of a cooking show. What will distinguish my cooking show versus somebody else's is the format that I give it. And, the look and feel of it. Maybe if it's semi-scripted, some scripting around it, the layout of how I would want to do it. A good example would be like a music show. You've got, Idols, which has got a format, and then you've got X Factor, which also has its own format. So both of them are commonplace ideas of a music competition, right? But how it's reduced and the format that it's given identifies it and separates the originality of one from the other.
Okay, so it's essentially the originality behind it. So you can have similar idea, but it has to be in itself different from its competitors around.
100%. It has to have originality. You need to have spent some, sweat of your brow coming up with it in the format that you've now reduced it to. Because obviously, like I say, there are a lot of commonplace ideas where the ideas are common, but your originality is what distinguishes your copyright in it.
Okay. Well, thank you for the elaboration with that. So then also with the others, so trademarks, which you said you also work with, is what identifies. People would identify with the brand. So as you said, Nike would be the slogan of Nike and the clothing and the logo of theirs. And maybe also with new ones like your phone, identifying that this one is Apple, and would that be also part of trademarking? If I'm on the
there. Yeah, so trademark, like I said, is more the identifier of a product or a service, and it's what normally you would apply to your senses, or how it visually and looks, how it sounds, and how it can be, how the visual and sound of it, or shape of it can be distinguished from another. So there are various things you can trademark. You can trademark the logo, you can trademark the color. I mean, if you come up with a color red that is different to any other color, then you can say, this is my red. I think often banks do that. And banks will come up with a specific color that identifies it, when okay, when I'm looking at this blue reminds me of a particular bank, or this red reminds me of a particular bank. So trademark is more the recognizing how we recognize signs, right? Or expressions, and then how we identify them, and we are able to go to market and be able to identify them differently to somebody else's.
Okay. And then,
but also maybe what's different, and it might be a leading question that you might have for me, maybe we'll touch on it later. There are different laws that protect each one. So there's laws that protect trademarks, there's laws that protect copyright, and there's laws that protect patents, etc., and designs.
Okay, so since we're also on that subject, what would somebody have to do, and how does somebody go around protecting their intellectual property under those branches and domains, and make sure that they follow those laws, as you said?
Okay, so in South Africa, we have the Trademarks Act, 194 of 93, I believe. And fortunately with that, it brings a little bit of certainty and ease in being able to register your trademark. So we do have common law. So let's just, for example, I'm trying to kind of dissect it. It's a quite a complex area. So I'm trying to dissect it so it's kind of more user-friendly. So let's, for example, say you've come up with a logo or a slogan, and you haven't protected it. You've been using it, and you've used it for the last 5 years, and now you realize, that somebody else it may be vulnerable to infringement. You then decide, let me protect it, and so that I could have registration rights, before somebody else uses it. You would then, under the Trademark Act, be able to approach the trademark registrar and apply for what we call a trademark application, right? Over time, once it has been accepted and inspected and advertised, and however long the process takes in different countries, then you would be issued with a trademark. You would be issued with a certificate of your brand, your logo, or your slogan. However, let's give an example that you hadn't protected it, and in that 5 years, somebody actually started using your idea. You would be afforded common law rights, but in other words, you would have to prove. And the inquiry is not as simple as showing up your certificate. You would have to prove that, yes, I was the creator of this slogan and logo, and I'm the first person to have used it, and I therefore believe that infringer X is infringing on my rights. But that would then fall under common law protection. Not recommended, because the inquiry would need to, you would actually spend money now having to prove that you are the actual originator of that slogan or logo. So it's always recommended that you be proactive, especially with regards to trademarks, and you seek protection of your trademark, because the law does provide for an avenue to be able to do that. You are able to protect it. I suppose with any area of law, you're able to protect yourself in any form, but because it's technical and legal, it's we are taught as lawyers on the laws of trademark, the Trademark Act, as well as the different classes of trademarks. And so it's always advisable to seek assistance from legal practitioners to help you identify where this is my slogan and my logo, and which class does it fit in. This is what it's supposed to protect, because also you are not able to have monopoly. If your slogan is, for example, maybe your show, if your slogan is discussions, early morning discussions, if you cannot monopolize that in every area of the world. In other words, if somebody came up with a plant that's called early morning discussions, they would be allowed to use that name, because they would not be you would not have protected it in a class of plants, right? I don't know, I hope that makes sense. So you have to make sure that when you request your protection, it is within that particular class that you're using that logo and slogan, or related classes to that. So that's on trademarks. Then when it comes to copyright is quite interesting, because it works a little bit different. We do have the Copyright Act. We also have Copyright Amendment Bill, which is currently being reviewed. Our act is quite old. It's as old as 1978. And obviously from 1978, we were not in a digital era as much as we are now. So we've had to look at reforming that act. And in reforming our act, we needed to make sure that it complies with our digitalization. So some of the things that are listed on the Act for protection may not necessarily be up to date with, digital distributions, etc. So in South Africa, we are still governed under the Copyright Act 98 of 1978. Which is quite old. Yes. And before the National Assembly, I believe right now we have the Copyright Amendment Bill, which has been drafted with the aim to reform the old act. I'm very involved in the copyright and policy discussions because of the interest of my clients. And I mean, unfortunately, the amendment that we have before us is not really providing the kind of copyright principle that we would wish, especially looking at global protection of copyrights. But that's a subject for another day. So that's the main law that regulates copyrights. So how does one go about it? Now, with copyright protection, copyright is automatic. So if you write a poem right now, and you write it, today's the 2nd of April, you automatically could put the date of today for your poem at the bottom. I'm sure you've seen the sign C in brackets. Yeah, so you can essentially put that in your poem, and you could email. But long time ago, before we had emails and internet, what we would have, you would then email it. You would then post it to yourself. You would send it to the post office, and and they used to call it it's a poor man's protection. You would post it and then post it back to yourself. So on the day that you posted it, and then when it came back, you could then identify that, okay, on this particular date is when my copyright was created. That is how you would have it as a registered to date. Now you can email it to your lawyer, you can email it, you can have an engagement, you can have different ways that show that indeed on this day you wrote this poem or this song, and you were the first one to come up with that materialism of that particular copyright. Unless it's, except for cinematography. Cinematography does require registration. So, but otherwise every other copyright is basically protected automatically from the moment that it has been reduced into a material form. So if you paint a picture, or take a picture of a photograph, for example,
The time.
it immediately, the moment that photograph is taken, that there's copyright subsisting in that work. The moment the song is reduced or recorded, there's copyright subsisting in that. Yeah, and that's that.
Okay, no, thank you very much for that. So copyright has that ability to already be protected if you have those, like the timestamps and the showing the proof that actually this is the date that you've done it and time you've done it.
Yes.
And then
Yes,
that'll be where
except for cinematographic films, which they need to be registered to provide for protection of that film. But everything else, like I said, is date bound according to whichever measure you decide to use at that given point in time. What I have, some of my clients will just email me their reduced copyright and say, look, I've got plans to do something with this. I haven't really decided how far I'm going to take it. Either I'm going to send it to producers, but just for registration of my copyright, I would like to email it to you for you to keep it on file for me. So yeah.
Okay. Oh, so there's that digital footprint that this is actually where it comes from. And this is the
100%.
Okay, so with that, what are some mistakes that people make when it comes to protecting their intellectual property? So within both trademarks and copyrights, what are some mistakes that they do?
Sure, several. I think because intellectual property is by nature, it's not necessarily tangible, right? So, when someone comes up with an idea in their mind, a brilliant idea, and they maybe put it in a material form, they start discussing it with others. That's the first pitfall. They start discussing it with others and say, I've come up with this brilliant concept for a series, and they go ahead and they share that information with others. That's the first mistake. And they share that information without having entered into maybe a non-disclosure agreement to say, look, buddy, I'm going to share this with you, but please know it is a copywritten idea, and I wouldn't want you to do anything with it. So you need to make sure that before you discuss your ideas or reduction of your ideas with anybody, or your original ideas, that you have actually entered into non-disclosure agreement. And if you haven't, then actually maybe refrain from discussing them until you've done some protection of it. If you share your logo with someone and or a slogan, the logos are quite, the devices, it's not easy, but it's easy to copy, but it's quite easy to say, well, this is unique, it's different to others. But I mean, if you come up with a very smart slogan, a good example would be, for example, I don't know if you heard Azikale Ziakala. statement that was coming. I mean, it's a Zulu word, but the individual that started using that word, he created a sensationalization around it. So in other words, it's his slogan now. He's used it for entertainment and in a particular class, but he may have used it without prior protection. So what does it do? It makes one vulnerable to others using it, and then you would now have to prove why that particular slogan or word actually belonged to you. So maybe just to go back. So the first thing is discussing your ideas with everybody and anybody without having entered into non-disclosure agreements, sharing them via email or whatever the case may be without having protected them. Then the third one would be perhaps not getting advice. I think that's the big one. I think by nature, everyone runs away from lawyers because of, they say lawyers are expensive, they charge you as you speak. Which reminds me, I must send you your bill.
I was about to ask that. Am I also being charged?
So
hour,
I think people run away from by the hour for every word. No, jokes. But on a serious note, I think people tend to run away from getting illegal advice and not realizing that it actually is going to end up costing you more. Because when you attempt to do these things on your own, I've had many instances where somebody has attempted to do their trademark on their own, but they've reached, they've applied for it in the wrong class, or they've applied for it, but there's another one existing. So they haven't done the necessary search to make sure that their name or trademark is available. So now they've spent money doing it, but now they have to spend money to actually maybe respond to somebody saying to them, you need to cease and desist using this trademark. They've done marketing, created websites, etc., and they haven't really gotten the necessary protection. So that's a big mistake. You don't want to invest money in your ideas or materially reduced ideas without. You'd rather spend money getting legal advice and making sure that before you proceed, you are proceeding in the right direction.
So essentially, preventing it from the onset. Make sure
exactly. I mean,
yes,
prevention. Exactly. I mean, I think when you prevent future litigation and disputes, it's cheaper than having to then defend yourself in courts or in a litigious situation. If you go and you come up with an idea that you think it's original, but a large company has already come up with that idea and protected it, you can actually be sued and liable for payments of infringing or passing off, what we call passing off. Passing off would be passing off as though you were related or part of that brand. So it's quite a costly exercise to proceed and not protect your ideas. That's the biggest, I think, the most obvious ones that I would say people enter into. And also another one, it's the obvious one is that, lawyer Google has become quite popular lately, where people go online and Google contracts and download those contracts and then use those contracts to enter into deals. Now, remember, a contract by nature, somebody offers something and somebody accepts it. So the contract you're downloading may not be related to what you're being offered or what's being accepted. So you might find yourself agreeing to terms that you had no interest in agreeing to. So it's very important that, as much as you want to save money upfront, you realize that the pitfalls you would fall into can end up costing you quite a lot of money. So yeah, I think that those would be, I mean, there's always other mistakes that we find in practice, but I think those would be the most common ones.
Okay, so with the first one you mentioned, also with the non-disclosure agreement, how would somebody go around doing that? Do you also need a lawyer for that to make sure that when you're discussing it with somebody, they will not? Or is it word of mouth? How would one actually go around having that agreement to protect themselves in the future from somebody sharing?
Well, I suppose the obvious one is getting a lawyer to draft one for you, related to what you're doing. Like I said, I mean, people oftentimes Google and download these ideas, these agreements, but like I said, it may not relate to what you're trying to protect. So it's, there are generic non-disclosure agreements, but ideally, We don't prefer we like to draft specific to the instruction of the client. So if somebody has a non-disclosure, they've come up with an app. You want that non-disclosure to relate to that app, right? You don't want it to just be general. Secondly, in your email, I think it's very important to have a disclaimer at the bottom of your emails to say that whatever is being shared here is copywritten work. Those are small little things that you can just add to as layers of protection. But also for those ideas that are protectable via statute, via legislation, you need to make sure that you first protect it before you even share it, before you even have to enter into a non-disclosure. Especially if you believe in yourself. And I always say, I think creative industry, because I'm mainly in the creative industry, artists or creatives undermine the value of their assets that they come with sometimes, not always. So, if you want somebody else to believe in your work, I think it's important that you first believe in it by investing it in it yourself, right? So getting legal advice and getting a proper agreement and registering your product, that's your own initial investment that you've made. So when you then approach investors, you essentially saying, I believe in this much, that I've taken the liberty to do protection of it. For example, a trademark, once you have a registration of your trademark, that protection lasts for 10 years and renewable. So that initial investment that you make is in my view, is quite worth your while, if you know that at least for the 10 years, you've got protection, and you know for a fact that at least if you don't use it for that next 10 years, you can try and come up and find investors, etc. So I think the simple answer is believing in your ideas and believing in your assets that you've come up with requires a little bit more than just believing it with your heart, but also just maybe taking we buy nice expensive shoes. So maybe putting aside some money to say, okay, this month or this next 6 months, I'm going to put away some money so I can pay for fees to help me protect my idea, protect my copyright. I need to stop saying idea because we don't protect ideas, but to protect my copyright or to protect my trademark.
I think it makes sense what you're saying, that you need to also show that seriousness and love for it, because you don't want somebody else to come in, take your idea, then do what they want with it, because it's something you've worked for, you've put your all into. So just taking that
100%.
extra mile to protect it and make sure that it's fully yours and fully secured and not having to worry about it in the long run. And you're saying with investors, also being able to show them that you are serious about this and you believe in it wholeheartedly and you're willing to go that extra mile for it. So 100%.
And with copyright, once you do the necessary steps to protect your copyright, it protects you for the lifespan of the copyright, depending on the type of work, obviously you're protecting, and then 50 years after your death. So that is something, that asset that you can actually pass down to your generations. And we often see it in our South African creatives, sadly, that you've got a lot of works that are sitting in public domain, but the family or the estate has never really benefited from the rights, from the exploitation of those works. A good case example would be, Imbube, the song that went to Disney and was used over years, and there really wasn't much gain to the family. But had there been recognition of the copyright at the time and awareness, the family could have been quite enriched from the usage of that music.
So enriching it, so also protecting it for you and your future generations as well, so they 100%. Can also benefit from it.
Yes, 100%.
So it's essentially also looking at the big picture.
Copyright, intellectual property, like the name says, is property. The same thing you would do with your land. You would want to make sure that if you own land, that you want to one day either sell it, either lease it, either develop it. So intellectual property is a property right, protectable and in the Constitution. So you those assets that you've created, essentially you place them in your will, and they fall to your heirs and your beneficiaries at your death. So it is a right that, I think, going back to your question, what mistake do we make? It's to not realize the weight of intellectual property, because it's not necessarily tangible, like land and buildings and so forth. People oftentimes don't realize that the value can sometimes surpass the value of owning a piece of land. So, I mean, if somebody owns a computer app or computer program, that value, every time it's used, either they get paid in the form of licenses, maybe royalties, that if you can, kind of like compare it, that could be like somebody earning rent from a piece of development property that they've now got.
So essentially, one other mistake would be people just putting it on the back burner and not seeing it as big as it should be seen. That it actually is an investment, not just something that you make, but it's an investment that you should always put in safeguards for.
Exactly. I mean, we all sit here around you. If you look around you, everything you have around you, the computers we're using, the program, whether it is Zoom, Teams, or whatever, these are all ideas which were reduced. So somebody's earning money from this very, moment that we're sitting in, having a cup of tea. Somebody's come up with that, so all of those things is what, if you look around you, you are surrounded by intellectual property. So somebody's either earning from it or not.
So you want to be also on the earning part of it.
Exactly. You want to be your investor in your own concepts.
And especially as you're saying with the entertainment industry, you want to, because people also watch shows, they enjoy being entertained, and you want to be able to earn from that. So as much as you want 100. To entertain people, but you also want to live off of it and enjoy the benefits of the entertainment you're putting out.
Exactly.
So that's also why it would be important for people to have lawyers such as yourself to ensure that.
Well, I definitely recommend they have lawyers such as myself. But yeah, I mean, on a serious note, it's the same way you would not transfer your property on your own. You would get a conveyancer, a lawyer, or I think it's the same value you would need to give to your creative expressions.
No, I agree with you that it's quite an important feat to look at it wholeheartedly and realistically. And as you said, everything around you, it's intellectual property, and the importance of making sure you earn from it cannot just benefit you, but in the long run also benefit future generations. And you don't want to be the person everybody's enjoying off of, but you're not getting anything from it. So
exactly.
Maybe also to end this off on a positive note, what advice would you give people both aspiring to become entertainment lawyers and also to protect their intellectual property?
Okay, so what advice would I give to people aspiring to be an entertainment lawyer? I would say, the first one would say passion. Passion is key. As I said to you earlier on, I was in the entertainment industry before I became an entertainment lawyer. So it's not an area of law you just want to just jump into for the money only. You want to make sure you actually have a passion for the industry. I think most entertainment lawyers that are really good are those who are passionate artists at heart, right? So they perhaps encompass a a creative side to themselves, and so maybe they've just were more interested in the law and the order behind it. So that's very, very key. It requires a lot of time and dedication. I mean, I'm as a South African entertainment lawyer, you would know obviously that a lot of our artists don't necessarily or have not really been fully informed on the rights that they have and how to make money from it. So a lot of them may not necessarily have the money to pay lawyers like myself. So some of the work that we do is to educate, and that's not always paid for. It's educate, it's to make sure that we share the knowledge, like we're having our discussion today. And that requires passion. I'm passionate about the industry. So I would want to see laws and policies that are going to protect our future generation. So that's quite important. And obviously then there are ways to then become a lawyer. You first become a lawyer. So you follow the normal route of becoming a lawyer. And, you know, you need to get your LLB degree. Then there are perhaps, especially with intellectual property, there are specific exams that you can just take to enhance your knowledge in the different branches of intellectual property. I was fortunate enough to, in my early days, to work within an intellectual property firm, which gave me quite sound knowledge of intellectual property and how it relates to the entertainment industry. So that's quite important. And I suppose on an ongoing basis, you keep yourself informed with the developments in entertainment industry as well as in entertainment law. I mean, I think recently we've just had the Oscars. So I was quite keen with the incident of the Oscars, just to know what the Oscar code of conduct looks like. So I took the liberty to read the code of conduct, and that's really just because I'm passionate about it, and then hopefully I would have clients that are receiving Oscars one day. So you would want to know the different conduct, you know, codes around the world, and the different laws in different jurisdiction. But yeah, I think it takes a long time. Law, just being a lawyer in general, or practicing lawyer, you first have to go to school, then you serve your articles, then you've got exams, and then you've got your, you know, overseas they call them bar exams. We've got exams here as well. And then if you go into private practice, that in itself is a process. You also have to do practical legal training for it. And yeah, so most of it, the behind the scenes is not pretty, but the front end of it, yeah, the front end of it is quite fun. I love working with creatives, and also I think it's important to identify that creatives are not like any other, any other person. So when you're working with creatives, it's very different to working with accountants. So you need to have an appreciation for the creative mind and not be very square. So in meetings, you know, your typical lawyer, black and white suit, or your typical idea of what a lawyer may be different for the entertainment industry. So how you approach your creatives is often unique. So I like that. It keeps us smiling despite the hard work that happens behind the scenes. We're very lucky, privileged to be have found this niche area of the law. Very few of us, Black people and Black women in particular, are in this space. So it would be nice to see a growth in that representation.
But hopefully through this, more people be inspired to jump into it and grow this specific sector and grow it more.
Absolutely, absolutely.
So since we're near the end also, what would you like to share? Maybe some projects or something so that people could also get a bit of a bite into what you might be doing? And
Sure. Obviously, I'm not at the leisure of sharing my clients and what I'm doing, you know, or privileged information. But we do some quite, like I said earlier on, the exciting project is being involved now with the Copyright Amendment Bill discussions, policy change, the reform. That's quite exciting. So we're quite visible with that, making submissions on behalf of our clients to the portfolio committee. Soon we'll be making submissions at the national, at the provincial level, the NCOP. And so that's very exciting space. Takes up a lot of my time, but it's quite exciting because I think it'll be quite interesting in a few years to look back and say, we were part of the reform of our legislation. Also, I mean, there's a few films being streamed currently, South African films. Some of our clients, we are assisting them in negotiating those deals with the online streamers. So just to avoid marketing, I'll avoid using names, but yeah, we have a few films, South African films and series that are being streamed, and we've been lucky enough to be involved in those deals and concluding on those contracts. We also quite involved with some nice South African names who are artists, painters of indigenous works. And been very privileged to be involved in that as well. We work quite a lot with international studios, not as they, not necessarily as our clients, but as media sort of facilitators locally. That's been quite exciting. I think that's been quite exciting. I think for me, the most exciting one, and maybe just bringing it back to home, is that my two older children, like I said, I'm a mom of 5, but my two older ones that are creatives. So the one is in cinematography, and the one whom you know all of them, but is into dance. And I mean, I think for me, the exciting part would one day to be able to represent them in their works. My son is already creating some exciting works, and I would be privileged and honored in my lifetime to have studied this, worked in this industry, and then also be a legal counsel for some of his works, and maybe my daughter's works as well, if she decides to take dance into into a professional space. They are both currently in the entertainment space overseas, and I think there's a lot of growth prospects there. And like I said, becoming this was a passion project for me. I was privileged enough to identify that my children were quite creative, and I then thought, it would be an honor and a privilege to be able to bring it home and assist them in their future endeavors. So yeah, I think my exciting project would be raising young creatives, and hopefully one day being able to fully be the legal counsel as the credits come up.
And then your name comes up as well.
Yeah, as the credits come up and my name then features there, that would be probably an emotional moment. One of those mic drops mic moment. So yeah, right now we're paying the fees for society to be enriched by what we do, and hopefully it'll benefit even our own personal people. But yeah, that's that. In terms of just particular clients, I think I will avoid mentioning client names. Some of it is quite privileged and private information.
Okay, no, that is understandable. So how can people also contact you for more information? I know we didn't touch on everything, so hopefully in future videos we'll all be able to as well, but for people who are interested in your services and also information on how to get into the industry, how can they contact you?
I think it'd be probably, I'm not sure where you're uploading this, but it'd be great to maybe put my LinkedIn link on there. But my website is still under development. I've taken quite a long time to do this for some odd reason, but we'll finalize that soon. It will be www.mfeka.co.za. But for now, you can find us via email, and my email, you can send it to info at mfeka.co.za, but I'll send you all this. Maybe you can put it on your
The description. Yes.
info, right? And but or directly you can send it to Phumla, PHUMLA .nobantu NOBANTU at mfeka.co.za. Yeah, but I'll share that information with you, and then you can put it in your description if anyone is interested to get in touch with us.
No, definitely. I will have them all here, but it was extremely informative. Thank you very much for doing this, and hopefully we'll have more discussions, also diving deeper into all the different topics within it, all the different branches and domains. So thank you very much for this. It was a privilege having you and learning more about this industry. And hopefully, if this channel goes bigger, we could also use your services as well.
You should use my services even before it gets too bigger, because then the cost will be higher.
Oh, no, then I'll definitely jump on it way before.
Yeah, no, it's an absolute honor and privilege that you would wish to interview myself. And I do wish you the best in your endeavor with the channel, to inform your market on various things and topics that you do. And yeah, and I mean, obviously, whoever comes and gets to see this and contacts us, we do appreciate the marketing opportunity that this may be providing. So like I said, it's a complex area that requires more one-on-one and direct engagement. So I look forward to whatever spin-offs may come from this. But yeah, certainly educating is one of my passions, and I'm privileged that you offered that opportunity.
Thank you for doing this. It was extremely informative, as I said. So thank you very much.
You are very welcome.